Thank you.
Balance remain 15 minutes.
Fairness and decency at work sums up the aspirations of all working people throughout the world in their working lives. It involves opportunities for work that is productive and delivers a fair outcome, security in the workplace, better prospects for personal development and social integration. In Ireland, it means, among other things, paying a living wage and giving decent terms and conditions of employment to vulnerable workers. Fairness and decency at work cannot be achieved by codes of practice or whimsical employer benevolence, but must be assisted by effective legislation that will right the enormous imbalance of power between the employers and employees. Business models based on a race to the bottom on standards inflict damage not only on workers but also on the prospect of a sustainable growth for all. Legislating for fairness and decency will benefit society because there is an enormous connection between decent treatment and improved economic performance. Fairness and decency at work means addressing the abuse of zero-hour and low-hour contracts. It indicates a real desire to abolish bogus self-employment contracts. It entails finally confronting the scourge of workplace bullying through the enactment of effective legislation. It means ensuring that service workers enjoy the same protections as every other worker under the transfer of undertaking regulations. It also necessitates changing legislation to extend the insolvency protection legislation to workers who are left without wages and other compensations when the employer ceases trading. Fundamentally, we need nothing less than employment rights that are fit for the 21st century to make people feel secure and productive at work. The motion before the Dáil this evening is how we were looking to the government to provide a fair framework of law and to promote fairness and decency in the context of employment practices. In other words, this motion is simply putting forward a workers' agenda, nothing more, nothing less. We welcome the Cleary workers here tonight, and we met them today earlier on. And of course, we are all aware of the situation that arose in Cleary's, the liquidation and the developments and how that was resolved. The principal disquiet, of course, that arose from that issue was the fact that the insolvency was preceded by a company restructuring, which involved separation of the trading business that employed the staff from its major asset, the Cleary's building. When the operating company was declared insolvent and put into liquidation, the employees lost their employment without any notice. Indeed, some of them learned about it on Facebook, or indeed any consultation. And of course, they didn't have payment of their statutory entitlements, but that was remedied by the right to recourse to the statutory entitlements to the Department of Social Protection. Because the state is obliged to pay all sums of money due to the company's employees. But it's the Department of Social Protection that bears this cost, which comes to about £2.5 million, Minister. However, employees in such a situation as Cleary's, some of them with 46 years service, some of them with decades of very sterling service and worthy service to the company, were left in a situation that they could not negotiate an enhanced redundancy package going beyond the statutory minimum. So they lost out hugely, not just in terms of their work, but in terms of any compensation that they could claim. An employer insolvency in a case like this impacts on two sets of legislation. Employee protection is the Redundancy Payments Act provides a statutory minimum entitled to redundancy payments. In addition, the minimum NOS in terms of Employment Act 1973 confers a right to payment of wages in lieu of NOS. And finally, outstanding wages, holiday pay, commission and bonuses are protected by the Payment of Wages Act 1991. And in the first instance, it is up to the employer to make these payments. But of course, if you're disappeared into the insolvency situation, legislation provides for payments by the Department of Social Protection in the event of insolvency. Then there is collective redundancy legislation. Under the Protection of Employment Acts 1977 to 2007, an employer who is contemplating a collective redundancy is obliged to enter into consultations with a view to reach an agreement with staff representatives. These consultations must take place at the earliest opportunity and at least 30 days before the notice of redundancy is given. The aim of the consultation is to consider whether there are any alternatives to redundancies. However, certain provisions of the Act are stated not to apply to employees in a business which has been wound up. And the reason given for this approach to date is that where an insolvent firm goes into liquidation, it can no longer trade. It can no longer accrue debts that is in no position to discharge. It will be difficult to keep staff in the books and expect them to work merely to serve out a 30-day notice period where the employer has no resource to pay those staff. And it wouldn't appear to be in the interest of the staff themselves if it merely delays access to social welfare. As Brendan Howell has said earlier, there have been a number of developments in response to the issues raised in Cleary's declaration, including Jared Nash's report to government dealing with the Companies Act and the application of it. Now, Section 599, which is basically it was first enacted in 1990 and re-enacted verbatim in 2014, is about bringing assets of a connected company into a liquidation on the grounds of fairness and equity. And this is borrowed from New Zealand legislation. It actually doesn't apply in the UK or Canada or Australia. But since 1990 it has never been invoked. And this is the area that should be focused upon, Minister. It seems to be designed to suit the situation that has arisen and the issue that has arisen in Cleary's. It is customs built, in my view, and it's time to throw off the shackles and utilise the legislative section to pursue the issue that has arisen in Cleary's. We don't know if it will be effective until it is tried. So let it be utilised and tested on this occasion to bring in assets of an associate company where there has been unfairness meted out to creditors such as the employees. The sole object of this transaction was to leave the state carrying the can for the redundancy it implies. It in effect represented an engineered bill presented to the Department of Social Protection. And Minister, if an ordinary person overdraws or overclaims or makes a claim that is not justified, they're rightly pursued if it is only €200 or €2,000 or whatever it is. And we now have a chance to pursue people for over £2.5 million. And let's try it. And we were saying that Cleary's is closed and the valuable assets were extracted from the company and the insolvent company put into liquidation and sent out all the bills, redundancy bills, holiday pay, sick pay directly to the Department of Social Protection. And what transpired in this case, if it escapes without question and without detailed investigation, well, you can be assured as night follows day, there will be attempted again. So let us utilise existing law and see if it works. And if it doesn't work, let us come back here, that's our job, to change it and bring forward laws that work. So I think, Minister, there should be no foot dragging in that. You will get, I'm sure, the advice of the Attorney-General, which you're entitled to get, and I'd be surprised if the Attorney-General doesn't arise. Now, the authorised officer, I'm not going to say too much about that because that's in the courts, but that's examining the situation whether the requirements of the Protection of Employment Act 1977 were in fact satisfied. The only thing I'll say is that contravention of the 1977 Act is an offence punishable on summary conviction with a fine of €5,000. The issue here is there's a 12-month time limit on prosecutions which are brought in the name of the Minister, and so therefore they must be brought by the 11th of June. And that's all I'll say about that. Now, we have the expert reports in this area, and Ministers Bruton and Nash announced a twin-track examination of protection and law for employees and unsecured creditors, particularly to ensure that limited liability and or corporate restructuring cannot be used to avoid a company's obligation to its employees and unsecured creditors. They appointed two experts to examine the legal protection of workers, particularly where operations and assets may be moved to separate legal entities as part of a restructuring. This examination will specifically look at situations where valuable assets in a company are separated from the operating entity and how the position of employees can be better protected in situations. Now, Kevin Duffy, chairperson of the Labour Court, and Nessa Cahill, a very experienced company law specialist, barrister, were given 8 weeks to examine existing legislation and also consider new solutions on how best to protect the interests of workers in such cases. And Minister Bruton separately requested the Company Law Review Group to examine legislation with a view to recommending ways company law could be amended to better safeguard employees and creditors. And as we know, Cahill and Duffy have reported their focus on how the interests of employees could be more effectively safeguarded where collective redundancies arise from liquidation following restructuring, in which assets have been put beyond the reach of the liquidator but been transferred to a related person. Among other measures to propose was that employees should in future have a right to consult with their employer for a minimum 30 days period before a collective redundancy can take place, whether the employer is insolvent or not. Where a related company or person is contemplating a significant decision in relation to an asset that will lead to collective redundancies, such as refusing to renew a lease or a sale of a property, they should be obliged to notify the employer, who will be obliged to trigger a 30-day consultation period of employees. Compensation for failing to respect employees' rights and 30-day consultation should be increased from 4 weeks' pay to 2 years' pay. And drawn from Section 608 of the Companies Act 2014, where the employer transfers assets out of the business with the effect of perpetrating a fraud on employees, there should be a mechanism for recovering the assets or the proceeds of a sale. So there you go. We have certain areas. The priority is to ensure that a situation like Cleary's never happen again. And our commitment of the Labour Party has always been that. If the law is tested and proves to be ineffective, then it must be corrected. But however, given that so far, as Cahill and Duffy put, Companies Act remedies that are already available do not appear to be in need of amendment, but more in need of use, the jury is still out on that. So, Minister, over to you. I also want workers who are in formal insolvencies. I have met numerous people who have fallen foul of this. Because if a company, thousands of companies over the last number of years in retail and construction and hospitality sectors have gone through the formal insolvency process, such as receivership, liquidation, bankruptcy or some other process recognised by law. And as a consequence, employees in those companies are able to apply to the State's Insolvency Fund for up to 8 weeks arrears of wages, holiday money, minimum notice, third-party awards. And that's very important, third-party awards, where the insolvent employers are able to pay it. And that's the Protection of Employees Insolvency Act 1984 to 2004. However, employees in companies that just fold up, and I see Deputy Collins here, he would know this very well as a solicitor, that just walk away, just stand static. And the employees at that company are actually prevented by law from applying to the Statutory Insolvency Fund. They cannot recover unpaid wages and other amounts due, like their colleagues in employment which have taken the proper insolvency routes, and they are left at an awful disadvantage. And I know people are owed 30 and 40,000 of this. And the fact is that employees in such circumstances are left bereft of not only their employment but also their due payments. And I think it's in breach of European law. Because the 2008 Employers Insolvency Directive, Article 2, subsection 4, specifically provides for protection of employees in insolvency situations, such as the informal ones that I'm talking about. So where payments have in fact been stopped on a permanent basis. And I think the High Court, I forget the case off the top of my head, has recently made a reference to that, which points to an inherent unfairness in the current law of the Republic. And a solution to this problem would be for the government to amend the existing legislation in line with the directive, and I think that was the original proposal in the 1984 Act. And this could then cover what's called informal or deemed insolvencies, where the employer has given up trading or where payments to employees have ceased for 6 weeks or more. And so all you can do is enact the regulation of the existing powers contained in Section 4, subsection 2 of the 1984 Act. An application of these regulations could then be dealt with by the Department of Social Protection, who already have responsibility under the Insolvency Payments and Employment and Redundancy Payments Acts. There's a lot of stuff here. One of the issues that I have concerned about over the years is that we have no statutory redress for bullying. You know, everybody agrees that workplace bullying is totally unacceptable. But the time has come now to take the long-awaited step of incorporating appropriate redress in employment law. There has been an abject failure in respect of legislative invention in this area, and it's all you have to go to court, you know, and it's an increasing problem in the workplace, and it has negative effects both for the alleged victim of the bullying and indeed the employer. For the alleged victim, you often find them stress, ill health, the productivity drops off, and of course the career development stalls. And for the employer, the workplace can become dysfunctional, poor morale, and then maybe costly litigation. So there's an increased level of complaints, but the insufficiency of existing measures to tackle the problem is leading to great frustration for both the employer and the employee. And there's no really formal channel for resolving bullying complaints. And the situation in work contrasted to what's available to harassment and sexual harassment claims, which are clearly and narrowly defined in the Employment Equality Acts. Such complaints can be processed through the Equality Tribunal and eventually to the Labour Court if necessary. In contrast, the worker making a bullying complaint has no defined redress under employment law. And the lack of statutory cause of action set out by the legislature has meant that the task of developing and applying appropriate cause of action has been left to the courts and to lawyers. And such a route is invariably costly, time-consuming, and of course it's traumatic for all of the parties. And if you look at the Task Force on Bullying 2006, it commented, if you like, adversely on the lack of formal procedures to deal with bullying, and indeed called directly for legislation to be enacted to give effect to these proposals. And legislation should obviously define what workplace bullying is, give an outline of the internal procedures that need to be put in place to deal with bullying complaints, and outline the formal route for adjudication of bullying complaints, which has to be legally sound and cost effective. And, you know, I mean, you have to have a definition of bullying, a comprehensive definition. Needs to obviously incorporate the tenets that where bullying occurs when an individual or group of individuals behaves unreasonably towards a worker or a group of workers. And you have to describe the type of behaviour which is unacceptable and to state that such behaviour must be deemed to create a risk to health and safety of work. Then you have to set out the use of internal procedures and the third-party adjudication. And eventually you can, a complainant can apply to the Workplace Relations Commission, which now is the one-stop shop for formal adjudication matter. And then the Director of the Workplace Relations can also dismiss claims if his or her considered opinion the claim is frivolous. But, I mean, then you have the redress, and it could give an order for a specified person to take specified action, or an order for compensation for up to 2 years' pay. And of course, ultimately, you can appeal to the Labour Court in the manner that's laid out in the Workplace Relations Act 2015. So bullying is a major issue, and it's surprising where it happens. You know, and again, with 0-hour contracts and in and out, I would like to know, I think there's a lot of places across the state where there's semi-state companies that might surprise you, where this type of 0-hour contracts are being applied and casualisation of employment. That has to stop, and it's my intention actually to find out over the next number of weeks how many state or semi-state companies are actually engaged in that practice. It would be a very bad example if any state or semi-state company was engaged in any practice of that and because we want to stamp that out, and we have the report from Limerick which we should actually act upon and implement. So those are just pointers, Minister, given in a constructive fashion for the Labour Party. You'll find us a constructive party. Not there, but this should be a weird, unashamedly going back to 1912 and 13 to pursue a workers' agenda, and we woe to the begrudgers.
Thank you, Deputy Penrose. I now call on Minister